afternoon. My name is Guillermo Patino, the chairperson designated of the New York City Loft Board. Welcome to our September 21st, 2023 public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multiple dwelling units, from commercial or manufacturing spaces to legal residential units that comply with the minimum standards of safety and fire protection in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of legalization, and prosecutes parties who violate the loft law and the loft board's rules. We'll first turn to a vote on the minutes from the June 15, 2023 public meeting. Are there any corrections or comments to the minutes? Is there a motion to accept the minutes?
So move.
Thank you, Mr. Hilton. Is there a second?
I'll second.
Thank you, Ms. Otto. Mr. Baer, can you please poll the board members?
Ms. Warwick, see if you...
Abstain.
Mr. Hilton?
Yes.
Mr. Delaney?
Yes.
Ms. Rosen?
Yes.
Ms. Otto?
Yes.
Chairperson Hilton? I'm sorry, Chairperson Patino?
Yes.
5 in favor, 1 abstain, 1 abstain, 2 abstain.
Thank you. Next on the
So they're
agenda.
not adopted.
Huh?
2 abstentions?
2, no, 1 abstain. 5 in favor, 1 abstain, 2 abstain.
Oh, 2 absences.
Thank you. Next on the agenda is the staff reports. We'll start with the report of our executive director.
Good afternoon. The first topic is our move. The Loft Board staff is now on the 5th floor of 280 Broadway. There's been no change to our number. The Loft Board still has a customer service window on the 1st floor. We ask that members of the public call the general number at 212-393-2616 to speak to the Loft Board staff in filing or for any other purpose to reach the Loft Board. Second is litigation. Since the June meeting, we received 1 decision and 1 new case. The decision involved the removal order 4938 and reconsideration order 5124 for 13 East 17th Street. In these orders, the Loft Board found that the units on the 5th floor and the 8th and 9th floors were subject to rent regulation. It was the owner's position that the units were not subject to rent regulation because the sale of rights were executed. The court found that the orders were not arbitrary and capricious and dismissed the petition. The owner has filed a notice of appeal in this case. The new case involves 385 Troutman in Brooklyn. The owner in this case seeks an order from the court directing the Loft Board to decide issues raised in the comment period of the narrative statement process. The staff is working with the law department on this case. The third topic is personnel. I have good news on that front. One of our paralegals will be starting on October 2nd. We don't have a date yet for the second paralegal, but based on emails I received this morning, I'm hopeful that the start date will be soon. With regard to our deputy position, we've completed the interviews and we've selected a candidate. The legalization process and the narrative statement, I have some information about that. All emails regarding legalization, including scheduling of a conference, requesting 45-day clocks, requesting certification of the narrative statement process, should be sent to the NYC Loft Board at buildings.nyc.gov email. The request will be handled in the order that they are received. You've heard me say before that the narrative statement process is probably the most important thing the board does. I must make you aware that we're having a staffing issue with the people that have been assigned this task. Florence and I have been handling this most important, Florence, Renee, and I have been handling this most important function at this moment, including all of the other duties that we're responsible for. It's been a challenging summer and a challenging time for us, continues. However, we're hopeful that with the onboarding with new personnel, our operations will improve, and we ask for your continued patience on this front. And that's it.
Thank you. We'll now turn to a vote on the cases on the appeal calendar.
Nice try.
Go ahead, Mr.
Yeah.
Blake.
No, I just have a couple of questions. With regard to, we're now in a new fiscal year, and legalization reports were due and registrations were due. How are we doing with those?
The story's going to update you.
Oh.
At least with the registration.
Okay,
Okay?
sure. And in the June meeting, you and I discussed that there seemed to be 80 or 90 buildings that we didn't quite have a category for.
Oh, I haven't checked that.
Haven't
I
had a
will,
chance.
but
Okay,
I will.
understood.
I'll send it to you.
Fine. And lastly, as at some point, I know you've been short-staffed, super short-staffed, getting a handle on how many cases are pending would be helpful in terms of, I'm particularly interested, now that there's more talk about alternate plans. Are a lot of alternate plans being filed? Is access an issue? Are there harassment claims? So if at some point in the next, between now and, I don't know, the first snowfall, how's that?
We can try it.
Yeah,
Certainly.
if we could get some more data, it would be very helpful.
Certainly, I can provide the number of cases pending in each category. That's relatively easy number that I can get. But how long they've been pending and where they are in the process will.
That's not as urgent to me as just
The numbers.
Yeah.
Okay. That's, yes.
That's it.
Yeah, I was going to say a few things about enforcement.
Go ahead. What did you say in the last paragraph? Yeah. Yes.
Sorry, everyone. Thank you, Chairperson Patino. The enforcement report will be extremely short this week due to staffing issues. I do have printouts for everyone. So for failure to register enforcement, there were about 107 buildings that did not pay annual registration timely. We ended up issuing 74 notices of proceedings. 32 buildings remain outstanding. In October, we will prepare proposed orders imposing fines ranging from $5,000 to $25,000. With regards to the legalization front, the Loft Board is currently focusing on all legalization efforts at this time, which includes scheduling narrative statement conferences, issuing notices to file comments, and issuing certification requests. Thank you. Any more questions?
Just one. In terms of the legalization reports, which have now become quarterly rather than monthly, how do we do getting legalization reports?
We did, we got about half of them. It was about a third, really, that we didn't get. We did issue some enforcement as a result of that, and we got some more. We we got some more back, but I haven't been able to get the specific numbers for you guys. It's been a little hectic for me, so I apologize for that.
Understood. Thank you.
Any other questions? Nothing from you, Ms. Roslin? Thank you, everybody.
Thank you, Ms. Story. We'll now turn to a vote on the cases on the appeal calendar. There's one case on the appeal calendar, and the case is 73 Tribeca LLC, docket number AB0127. And Ms. Chung, our law intern, will present this case.
Hello, I'm here for a 73 letter. Just want you guys to know that I'm present.
Thank you, Chairperson Patino. The owner of 73 Lerner Street filed an appeal challenging an administrative determination imposing a $17,500 fine for owner's failure to maintain the permit. The owner requested a waiver of the imposed fine based on its limited resources and an alleged lack of access. Because the owner did not file an access application with the Loft Board, the owner's claim based on lack of access is unavailing. Limited financial resources similarly do not relieve the owner of its duty to legalize or the fine imposed for noncompliance. Financial inability is not a circumstance beyond the owner's control and not a justification for the failure to comply. The proposed order denies the appeal because neither allegation provides a basis to reverse, remand, or modify the administrative determination pursuant to 29 RCNY Section 1-33F. Thank you.
Thank you. Are there any comments on the case?
Yes, I'd like to have a comment, please, if I may.
No, everybody's muted. Let me just write something in the chat and say there's no participation. That's good. Yes. Everybody's muted. Let's just write something in the chat.
Is there a motion to accept the case? I'll move. Thank you, Mr. Duane. Is there a second?
I'll second.
Thank you, Ms. Roslin. Mr. Baird, can you please pull the board members?
Mr. Bauer?
Yes.
Mr. Hilton?
Yes. Excuse me, yes.
Mr. Delaney?
Yes.
Ms. Roseman?
Yes.
Ms. Adam?
Yes.
Chairperson Patino?
Yes.
6 in favor, 2 absent.
Thank you. Next are the cases on the summary calendar. There are 4 cases on the summary calendar, and we usually vote on these cases as a block. Cases are the Bracho v. Haslacho Corporation, docket number LS0298, Madeline Rombez, docket number PO0123, Michael Lennox and Wiley Matthews, docket numbers TR1366 and TR1375, and Darren Francis Epoli, docket number TR1453. Are there any comments on these cases? Mr. Delaney?
Yes, with regard to case number 478 Kingsland Avenue, thankfully, this is the only case on the agenda today that was settled through a stipulation, and we have the usual Loft Board fig leaf of we neither accept nor reject the remainder of the terms of the stipulation. We just deem it withdrawn. It's quite a remarkable stipulation. It is more brisk, for my opinion, that if an application comes in seeking coverage and not raising other issues, and if the answer comes in disputing coverage but not raising other issues, to then have a global settlement that addresses all kinds of issues, to me seems not the way to proceed, but that's just my opinion. And it's the only time you'll hear it from me today.
Thank you. Is there a motion to accept these cases?
Second.
Thank you, Mr. Bowers. Thank you, Mr. Hilton. Ms. Rivera, can you please pull the board members?
Mr. Bauer?
Yes.
Mr. Hilton?
Yes.
Mr. Delaney?
Yes.
Ms. Roseman?
Yes.
Ms. Addo?
Yes.
Chairperson Patino?
Yes.
6 in favor, 2 absent.
Thank you. We'll now turn to vote on the cases on the master calendar. There are 3 cases on the master calendar. The first case is 521 West 26th Street, docket number TN0229. And Ms. Chung, our law intern, will present this case.
Thank you, Chairperson Patino. The tenants in this case filed an application seeking a finding of non-compliance with the legalization timelines. In its defense, the owner attempted to shift the responsibility for its failure to legalize to the Loft Board and the Department of Buildings. However, as explained in the proposed order, the owner has an unconditional duty to legalize and discuss any issues with legalization with the Loft Board. The owner failed to do so. The report recommends a finding of non-compliance but does not recommend a fine based on due process grounds. The staff disagrees that there is a due process concern here. Section D of the instruction sheet provides a notice of the potential of a fine by stating that the Loft Board reserves the right to impose a civil penalty in accordance with 29 RCNY Section 2-11.1 for every violation of the Loft Board rules, whether or not the applicant requests the imposition of fine and penalties. The owner had notice of a potential fine. The proposed order grants the application and imposes a $100,000 fine. Oh, $10,000 fine. Excuse me, sorry. Fine for, sorry, surprised a lot of people. A $10,000 fine for non-compliance with the legalization deadlines, for achieving 7B compliance and obtaining a certificate of occupancy. Thank you.
Are there any questions or comments on this case? Thank you, Ms. Chung. Is there a motion to accept the case? Thank you, Mr. Delaney. Is there a second?
I'll second.
Thank you, Ms. Otto. Ms. Rivera, can you please pull the board members?
Mr. Bauer?
Yes.
Mr. Hilton?
Yes.
Mr. Delaney?
Yes.
Ms. Roseman?
No.
Ms. Addo?
Yes.
Chairperson Patino?
Yes.
5 in favor, 1 against, 2 absent.
Thank you. The next case on the master calendar is 226 Franklin Street in Brooklyn, docket number PO0140, and Ms. Story will present this case.
Thank you, Chairperson Patino. This case is about a tenant seeking protected occupancy status. Owner opposed tenant's application and alleged deregulation of the unit by a sale of Article 7C rights pursuant to MDL 28612. The purported sale was executed in 2014. The issue here was whether the 2014 sale of Article 7C rights was effective. The Loft Board's orders in 99 Sutton LLC and Matter of Bozeman established that only a residential occupant may sell Article 7C rights pursuant to MDL 28612. The proposed order rejects owner's claim of deregulation based on sales of rights. During trial, tenant presented 2 witnesses, Mary Ann Allison, one of the protected tenants that allegedly sold her Article 7C rights pursuant to MDL Section 28612, and Heather Choi, the protected tenant of another unit in the building. Mary Ann Allison testified that she and her husband, who is now deceased, vacated the unit in August of 2012. They did not pay rent after August of 2012. Heather Choi testified that she conducted business out of the unit in 2012, and she was certain that the Allisons moved out in August of 2012. Judge Garcia found their testimony to be credible. Owner only presented testimony of Martin Kaufman, who testified that the Allenses were living there in 2014 but did not provide any corroborating evidence. Judge Garcia found this testimony to be self-serving. The preponderance of the evidence established that the Allisons were not residential occupants of the unit at the time of the purported sale. The proposed order grants the protected occupancy claim based on voluminous documents produced by tenant listing building as his primary residence, including tenant's 2016 voter registration records, tenant's 2019 New York State driver's license, and a series of bank statements from several banking institutions from 2015 through 2018. Owner did not produce any evidence to rebut tenant's claim. Thank you.
Are there any comments or questions on this case? Thank you, Ms. Story.
Thank you.
Is there a motion to accept the case?
So move.
I'll second.
Thank you, Mr. Hilton. Thank you, Mr. Billing. Oh, go ahead.
I'm
You have a
sorry.
question?
On the language of the order, it says background. On November 23rd, 2020, Brett Herman, the protected occupant of Unit 405, filed an application seeking protected occupancy.
You're on.
I'll ask the question again in a second.
I know we're moving quickly.
So we had Mr. Hilton and then Mr. Delaney
Yes.
make the motions. So you can
Yes.
pull them for the members.
Mr. Bauer?
Yes.
Mr. Hilton?
Yes.
Mr. Delaney?
Yes.
Ms. Roseman?
Yes.
Ms. Adam?
Yes.
Chairperson Patino?
Yes.
6 in favor, 2 absent.
Thank you.
Mr. Chairman, before we go to the last case, I just noticed that we did not spend any time discussing the 2 fact sheets that were distributed. Is that intentional? I have some notes, but I can provide them to the executive director at some other point in time if that works better.
It's fine.
Okay.
Thank you.
I want to hear your comments too. We have 5 minutes.
All right, so let's do the last case and then we'll
Okay.
discuss the fact sheets.
Sure.
So the final case on the calendar is 476 Jefferson Street in Brooklyn, docket numbers P00147 and TA0280. And Ms. Oyegwe will present this case.
Thank you, Chairperson Patino. Good afternoon. Tenant filed 2 applications in this case. One seeking protected occupancy status, and the second one was a rent dispute application. In the answer, owner alleged the regulation of the unit by a sales of Article 7 right pursuant to MDL Section 286(12). The issue was whether the transaction by the prior occupants of the unit constitute a valid sales of Article 7C right pursuant to the same section, MDL Section 286(12). The record in this case includes the testimony of the prior protected tenants who allegedly sold her Article 7 rights. The prior tenant testified that she was unfamiliar with the Loft law right and she did not know her unit was covered by the Loft law. Owner presented testimony of Mark Bourbon, who alleged that he personally paid the prior tenants the sum of $10 cash and was present when the tenant signed the sales agreement. The preponderance of the evidence establishes that tenant was not aware she had Loft law rights and she did not intentionally relinquish the Article 7 rights. Judge Casey found the testimony of the prior tenants credible. The proposed order before you rejects the purported sales of rights and grants the protected occupancy application. Any question?
Thank you, Ms. Ayagwe. I'll turn it to Ms. Roslin to discuss the language in the order.
Yes, it just at the very beginning, second paragraph, background, it says that Brett Herman is the protected occupant of Unit 405, filed an application seeking protected occupant. So he would not already be a protected.
Right, so it should be the occupant, not protected.
Thank you.
Thank you.
So what will the order read?
Just remove the protected word, this word.
Okay, so it'll say filed an application seeking occupancy.
Protected, no, this protected occupant,
Okay,
the first one.
okay, just the occupant.
Yeah,
So we'll revise the order.
yes.
Is there a motion to accept the case?
So moved.
Thank you, Mr. Hilton. Mr. Bowers is a second. Thank you. Mr. Rivera, can you please pull the board members?
Mr. Bauer,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Rosa,
Yes.
Ms. Adams,
Yes.
Chairperson Patino.
Yes.
6 in favor, 2 absent.
Thank you. We'll now have a discussion about the fact sheets. I'll turn it over to Mr. Delaney.
Thank you. I think these are very good and very helpful. And I know the narrative statement piece is still a work in progress. On fact sheet number 3, the letter of no objection, in part 2, application, the 1, 2, 3, 5th bullet, a letter of no objection cannot be processed unless it includes a copy of the DOB objection sheet, required items list, with the requirement to obtain a Loft Board certificate is the last objection, but we haven't defined Loft Board certificate, to my knowledge, anywhere in it. So I think we just need a couple of words there. But we do capitalize it, so in the right-hand column, the very last word on the sheet is Loft Board certificate, not capitalized. So. And on the sale of rights overview and sale of improvements, you packed a lot into one page. And my feeling is almost that there might be reason to make them 2 separate sheets so you have a little more room for the sale of rights, because there's a lot crammed in there. Because we introduced the concept of the fact that the occupant and the owner may negotiate the purchase, except for sales between the owner and representative of the deceased occupant's estate. The occupant must be residing. Then at the end of that 3rd paragraph, if a tenant and owner agree to a sale, the owner will ask the tenant to sign a sales record form, which is actually it's the Loft Board's sales record form. I think it would be helpful to make that clear that there's a prescribed form. And in the last piece under sale of rights, the effect of sale of rights, the unit will no longer be subject to rent regulation where coverage under Article 7C was the sole basis for such rent regulation. We still want to keep that in, despite the wisdom of the Court of Appeals.
Well, there's just, the Court of Appeals held that there's a sale.
Well, and what was it, Acevedo?
No, it's Aurora.
Aurora, yeah. I'm proud of it. It doesn't hurt to keep it. Okay. Then on the sale of improvements, it could also use a little more fleshing out, I think, which is why I think rather than try to cram them both onto one side of one sheet, you might have them separate and reference each other. But the second paragraph under sale of improvements, a protected occupant may sell improvements to the owner or a prospective incoming tenant at any time. It leaves out the whole Carl Weisbrod elegant structure of it has to be offered, you have to find a potential incoming tenant to make an offer that's arm's length. And then the owner has the right to object to that or match it. And so, as we tried to explain this to loft tenants back in the day, it was the pit and the pot, the potential incoming tenant and the potential outgoing tenant. So that whole dance is I think, is why sale of improvements needs another couple of inches of text to delve into that. And then on the improvement sales record filing, within 30 days of the sale of improvements, the owner must file an improvement sales record form which provides the following information, : nothing. It goes to failure of the owner to file the form within 30 days. There's a
Information.
there's a whole something missing there.
Okay.
Yeah. That's it. Thank you.
Thank you. So this will conclude our September 21st Loft Board meeting. Our next public meeting is scheduled for October 19, 2023. Thank you, everyone.